if I can somehow share a screen, I'm happy to do so. If not, not a problem.
Yeah, let me go ahead and do the share screen function. I'm going to allow you to share screen. Go ahead.
Okay. Pulling it up. Can you all see the slides okay?
Yeah.
Perfect. Alrighty, good morning all. So as briefly discussed, my name is Sydney Collier and I represent the plaintiffs, Covey Equipment LLC and Slim RGV Finance. As a bit of a background, we're here today to discuss plaintiff's motion for summary judgment. This was a traditional and a no evidence summary judgment motions. A bit of procedural background is this all stems from essentially the purchase of 4 restaurants, the subsequent non-payment under those restaurants, and then this lawsuit proceeded. Plaintiffs alleged claims of breach of contract, unjust enrichment. However, for today, we are just here on the breach of contract claims. In response, defendants filed a counterclaim and have recently asserted an affirmative defense to plaintiff's breach of contract claim for fraud and fraud in the inducement. And we moved for a no evidence on those claims. Starting first with the no evidence, because I think it'll move through a bit quicker. Because it's a no evidence, of course, under 166A subsection I, the defendants have the burden to produce evidence for each and every element that was challenged.
Ms. Colliers, I'm very familiar with the burden, so you can skip beyond that.
Well, we'll get to it then, Your Honor. The first thing is there's no evidence supporting all cause of action. The most glaring one is the lack of a material representation by anyone before this court. And I think, Your Honor, there's a bit of dot connecting that we have to do with the response brief to somehow try to make sense of the argument that is put forth by defendants. But first and foremost, there's no evidence or allegation that Slim RGV Finance made any alleged misrepresentation, that there was any agent speaking on his behalf. That is why, as an offset matter, Slim RGV Finance, the claims against Slim RGV Finance should be dismissed. Additionally, as we get through it, some arguably representations that Mr. Rajput puts in his declaration, which you read the briefing, we object to the declaration as conclusory, but he does generally state that Mr. Rajput states that Mr. Hamida, who is a member of Covey Equipment LLC, stated that Mr. Hamida represented that the restaurants as a whole were profitable. But Your Honor, you've seen it. I'm happy to direct you to it. The financing statements that Mr. Hamida provided, which Mr. Rajput agrees he saw, show a collective loss of over $500,000 for 3 of the restaurants. So it's the alleged misrepresentations aren't even supported by the evidence before this court. I could go through all of these, Your Honor, but again, that's not my burden. That's defendants, as you know. Plaintiffs moves that they haven't shown any of these: reliance, knowledge of the falsity, or injury. They also, Your Honor, defendants also kind of move quasi for fraud by non-disclosure in their counterclaim. Just to cover the basis, we'll address those as well. And it's very similar to their first fraudulent by misrepresentation claim. There's no evidence supporting really any of these causes of action other than that the parties entered into a contract. And that's about the only element that plaintiffs agree exists, is there were contracts entered into. However, there was no omission, and importantly, there's no evidence before this court that plaintiffs had a duty to disclose anything, even the alleged omissions. So for those reasons, Your Honor, because defendants haven't met their burden, that we believe that the claim should be dismissed against plaintiffs. Moving quickly through our traditional summary judgment, of course, it's a breach of contract claim, which is straightforward and simple and supported by the evidence. The existence of a valid contract, you've seen there were 2 loan and security agreements entered into by the parties. On one hand, you had Kobe Equipment LLC and both the defendants, and then on the other hand, you had Slim RGV Finance and both of the defendants. As evidenced by the promissory note, these are the two and the signatures below there. And in the whole agreement, it says for value received, which was that $300,000 that underlines this loan and security agreement and the promissory note. Now, it's under these agreements, and you've seen it in the brief, Your Honor, that defendants were required to make payments as of December 2018. No payments were made, and subsequently, the contract was breached. It was due to this breach that, again, as you've seen, default notices were sent, there was no response, and now we're here today for this breach of the promissory note, which clearly says for value received and for the previous signatures that we've seen. Your Honor, it's because defendants have failed to assert any evidence supporting their affirmative defense, and because of the clear summary judgment evidence before this court, that plaintiffs asked that you grant their traditional motion for summary judgment and enter into facts supporting that defendants breached both loan and security agreements, and also, Your Honor, that you dismiss the counterclaim asserted against both plaintiffs. And I am happy to answer any questions the court may have.
Response?
Yes, Your Honor. May I proceed? We have responded. First of all, we would respectfully disagree with counsel with respect to our providing evidence of both our affirmative claims of fraud and fraud of the inducement and our defensive claim of fraud, which would defeat their traditional motion for summary judgment. We have provided in the affidavit and the attachments to the affidavit, not only evidence of misrepresentations that were made with regard to the financial statements, we have misrepresentations that were made with regard to payment of franchise taxes, with regard to payment of the taxes due and owing to the taxing authorities of the state of Texas, with regard to landlords being silenced from telling us that there were liens on the properties that impeded our ability to deal with leases. All of those things are not only laid out in the affidavit, Your Honor, but you'll see in the attachments, there are real-time responses and interactions between my client and the counsel, the duly authorized representative and counsel for the plaintiffs, where he's claiming these things in real time. Hey, he told me he was my brother. Now he didn't agree to the 6-month forbearance. He didn't agree. We talked about, in fact, there's an email, Your Honor, from the attorney where he says and confirms that the taxes were paid on the properties and on the businesses. And then afterwards, we find out there's a delinquency. And he says, I was wrong. I thought I was right, but I was wrong. And these are in real time. These are all issues of fact, which preclude any granting of summary judgment with respect to their affirmative claims and also with respect to their no evidence claims. So I don't want to belabor. If the court's read these, they're in there. Now, I also
let me kind of give you my initial thoughts on this. And again, I just got the reply, so I haven't digested it fully, but I did read it. It seems pretty clear to me that the plaintiff's affirmative claim for breach of contract should be granted. I mean, it's not a basis to deny a summary judgment or breach of contract just because your client didn't read the contract. And so the question I have really is involving your counterclaim.
Yes, Your Honor. And if I may, I think the issue of fraud, our affirmative defense of fraud, would in fact raise an issue of fact with respect to their breach of contract. If they're claiming that we breached the contract and we're claiming that you defrauded us and there was fraud in the inducement with regard to that contract, that's an issue of fact that needs to be tried that precludes the granting of a summary judgment on the contract claims based upon the way I've handled things over the years and based upon my understanding of the law. The affirmative fraud can be used both as an affirmative claim and as a defense. And in this case, it's been used as both. And as such, it would preclude granting of summary judgment on the affirmative claims of breach of contract at this juncture.
Ms. Collier, what do you think about that? I think he has a point. I do think there's a fact issue as to fraud here. I agree that you guys have proved up all the basic contract issues, the damages and everything like that. And feel free to tap in Mr. Stafford if you need to. I know he's here as well, but you don't have to. It's up to you.
I love getting double teamed.
Yeah, that's all right. That's all right. What are your thoughts on that? I mean, if we think about it, if this was a jury trial, and you have an affirmative defense of fraud and you have a counterclaim for fraud, couldn't we just try those issues, or kind of what are your thoughts?
Your Honor, my first thought, and Paul, of course, jump in if you want to add. My first thought is specifically what contract are defendants alleging they were fraudulently induced to? You've read the briefing. The first purchase agreement for these 4 restaurants was entered into July 7th, 2018. We are suing under this promissory note and loan and security agreement for $300,000 that was entered into October 31st, 2018. So a bit of the struggle that I had with the response and what the Dallas Court of Appeals has, explicitly condemned is you're kind of doing a connect the dots to figure out exactly what contract defendants are claiming at issue, because, Your Honor, that depends on what parties are before the court. And it seems like they're arguing that they were fraudulently induced to purchase these 4 restaurants, which means we're talking about a July 7th, 2018 contract with parties not before this court. And for that basis alone should be dismissed.
I apologize.
No, please.
I thought you finished. Yes, Your Honor. I think if you look at our affidavit, and our affidavit lays out all of the agreements. It is set forth in the affidavit, each agreement specifically, and we're claiming that we're fraudulently induced into all of them. And it was the same person, Mr. Hamaday, who was the person that was making all of the overtures, representations, discussions with my client until the time that the lawyers were involved, when there were discussions by and between the duly authorized lawyer in this case. So it's all there. And in fact, getting back to their summary judgment, Your Honor, they didn't even properly put in their contracts. And I'm not trying to play a procedural gotcha, because I don't like that. It's not my normal modus operandi, but they did not properly authenticate and put in these contracts they're allegedly suing under. They didn't even put in all the contracts that are at issue. We did. We placed all the contracts at issue, identified them, and said we were fraudulently induced into all of them. That's what the summary judgment evidence is as we speak today. Their evidence is insufficient to even properly identify and authenticate the contracts that they're trying to get summary judgment on.
Response?
Plaintiffs disagree. Of course, Your Honor, you've seen the evidence. The only contracts that have been proven up and submitted before this court, ready to go under Texas Rules of Evidence 90210, have been produced by plaintiffs, properly before 2 weeks of trial. And of course, the contracts were properly attached to our motion. So they're before the court. But getting back, Your Honor, to your first question of fraud, I think defendants have now clarified that they're claiming they were fraudulently induced to these separate contracts. And I'll, of course, remind the court, or I can even point you to these documents where, again, the first one was signed July 7th, 2018. The second one, I believe, was in August, and then finally in October. The very email that defendants are relying upon about these property taxes, or I guess taxes owed, occurred in November, which is well after all 3 contracts were entered into. So to say that
that's not the only thing they're complaining about, though, right?
Yes, Your Honor. And in fact, just to lay into that, that's when we found out. It was in November that we found out that particular representation was false. And we immediately, in real time, made an issue of it. We thought at that point that the taxes were being, this is the analogy we're talking about here on the taxes, Your Honor, is if I buy a house from you in October and then I'm responsible for the property taxes from October on. In this instance, my client got stuck with the all the taxes from January to October. He was told he wasn't going to be responsible for those. He thought that was the case. And in November, when he found out there was a problem, that's when he was told, we changed the agreement on you, didn't tell you. And that's the basis for the fraud on that issue. And then the other thing I just want to mention, Your Honor, on the procedural side is that what counsel did here was, in the summary judgment evidence that was provided to the court, these were not properly authenticated contracts. The evidence does not raise it. What they did afterwards was they put in the affidavits that were done not part of this pleading, but I guess in contemplation of trial, they filed their affidavits 14 days before trial, separate document, but well within the 21 days of this hearing. And so these documents aren't properly before you with the requisite 21-day notice I'd be entitled to. And the record's going to show that. So they fail procedurally. But again, we think substantively there's issues of fact here on the fraud on both ends that would preclude the summary judgment. And counsel hasn't brought forth anything that would at least alleviate an issue of fact.
Well, let me kind of give you my thoughts on this at this point, which is that this kind of, and I'm not sure the history of why we're kind of where we are. It could be because of COVID or some other reason. I mean, trial is on Tuesday, and generally you want to have summary judgments heard at least 30 days before trial. We can handle this a couple different ways. If there's no agreement, I'm inclined to deny the summary judgment as to the fraud issues, I guess, and grant it as to the breach of contract. How that would work exactly as to the fraud defense, wouldn't be ruling on the fraud defense, and so we would need to talk about how that would work. If we want to go to trial on the 19th, if you guys want to move the trial for a few weeks, give me a chance to kind of digest everything in this new reply. I don't mind trying this in 2 or 3 weeks and give you guys an opportunity to, or give me an opportunity to fully digest everything in that reply brief. But if you guys just want to go to trial next Tuesday, you're all kind of locked and loaded on that. I'm okay with that too.
Your Honor, may I address that? I'm inclined. I'm willing to ask the court to give the weeks, because I was going to say to the court, I'm not sure how you're trying the cases logistically, but if I'm doing it by Zoom, I'm at a disadvantage right now that I'm trying to work through. I'm on Zoom right now, but I'm not through my GoToMyPC. So when I work remotely, I work through my GoToMyPC. I've got my computer in front of me. I can't get on Zoom through that. So I don't have my documents. So if I was going to, as counsel, as Ms. Collier, shared documents, I'm not in a position to do that because my document management system is on my GoToMyPC. I'm trying to work that through with my technology people, but I will not. I have a choice. Either I get on and I have no audio, or I can't use the documents. And I'm trying to work that through. I was going to ask the court for a couple of weeks to let me figure that out if we're doing a Zoom trial. I assume that we're not doing an in-person trial because of the current order in place, but I'm also,
true.
And I'm going to be 64 years old and I'm a cancer survivor. So I'm not really looking to sit in a hotel room and do any of that. So I would ask.
Let me just say one other thing, and I appreciate that, and I have no problem with moving this a couple of weeks. I don't know what it's like down in Houston, but in Dallas, and I imagine it's the same in Houston, is before COVID, we were very, very busy trying cases every week. Our caseloads have gone up 50% since I started as a judge. And now we have this bottleneck or dam basically keeping us from trying jury trials. And so my goal, and just to be able to handle my docket, is to try as many non-jury cases, especially more complex ones like this one, while we're in this kind of hiatus from jury trials. And so I'm not opposed to moving this for a couple of weeks. I don't want to move it much longer than that. But Mr. Stafford and Ms. Colliers haven't had a chance to speak, so let's hear from them.
Your Honor, plaintiffs would like to proceed on Tuesday. As you are aware, it was a bit of a struggle to get us to mediation, and this case has been reset before. Plaintiffs have been ready, and we'd like to get the relief that plaintiffs are entitled to. I will add as well as there are other outside proceedings regarding this defendant that could put plaintiffs at a disadvantage because this trial is continued and defendants continue to try to delay the inevitable, really, is proving up these claims and getting a judgment against Mr. Rajput and his company. And Your Honor, I'm also happy if you'd like to quickly touch on one more time on their fraud claims or fraud by admission, and again point out that the evidence does not support all of the elements. There's no allegations of a duty that Mr. Hamada had. Again, there's no allegations or really evidence supporting that Chris Durad and RGV Finance are made any representations and or omissions. It's just not there. And I understand the text messages were produced. Those are not properly authenticated or before the court. I can understand that if the court has already seen them, the courts have seen them. But I do just want to reiterate and show that it wasn't plaintiff's burden to prove.
Ms. Collier, unfortunately, you kind of can't have your cake and eat it too. Either I'm not ruling today on the fraud. So
Okay.
as I said before, and I'm not, just so it's clear, I'm willing to dive a little deeper on your summary judgment, but I just got this reply brief, which was over 100 pages. And so, and in violation of our new standing rule, but I'm not going to fuss with you about that. And so I'm going to, if you want to continue this for a few weeks to give me a chance to go into a little more detail about this, to see if I can rule on some of the more of these summary judgment issues, I'm willing to do that. Or we go to trial on Tuesday.
Your Honor, the problem, I still have that I still have to deal with my technological issue. And if the court's going to proceed, I mean, even if I get a week, I got to figure out how to do this because I'm going to be at a real disadvantage. I'm not going to be in the courtroom. I'm not going to be able to put on, I've got to figure out how to put on my evidence.
I'm going to leave it up to Mr. Stafford and Ms. Collier. I mean, I can see if they want to cut you a break. I don't mind moving you a week or two. If they want to go forward, the case is set for trial, and I'm flexible either way. But if they don't want to move it, I don't see how I can move it.
Well, I don't want to be the bad guy, and since we are on YouTube, when you're talking about cutting somebody a break, I mean, I think we've been very understanding throughout. We've had to try to move this case a couple of times due to various other issues, medical or otherwise, involving the defendant. And I think, Your Honor, as Ms. Collier said, we're ready for trial on Tuesday. If that means that we don't get to have the consideration on the fraud claim on the MSJ, that's fine, because our clients are ready. We're ready. We've planned on May 12th. It's been on the calendar 4 months. That's FOR. And we're ready. I understand there's technological issues. We all have technological issues, and I'm not besmudging or belittling anybody on this call's technical issues, but we've all got challenges. And so we're ready. We announced ready, and we'd like to proceed if we can on Tuesday.
Your Honor, all I could ask is I could urge for a couple of weeks of reprieve. I understand where the court is, but I'm asking for that just so I don't want to have to try this case and do it to where I'm doing my client a disservice. That's my only concern.
I mean, I'm a big believer in everyone having an even playing field, but this has been set for quite a while. And if the plaintiffs are willing to bump it a couple of weeks or even a couple of days, I'm happy to do that. But if they're not, then I don't see that I can really do this given the situation.
Would they consider a week just so I could figure out how to do this? I've got to, between now and Tuesday is going to be difficult for me to figure out how to be able to present my evidence. And so I would ask them to at least consider a week.
One thing I would say to all of you, and Ms. Cervantes is on the phone. She's one of my new interns that she'll be watching the trial whenever it occurs. There'll be a much larger group if we do this, if we wait a couple of weeks. But there's a lot of young lawyers out there who are really good with technology. and maybe you can get one of those or law students to help you. I'm not saying you have to, but we all have to adjust, and I'm not trying to give anyone a hard time. And but if the plaintiffs are ready to go, the court doesn't see that I can move it. If the plaintiffs are willing to move this a week, I'm okay with that, or 2 weeks, or even 3 weeks. But if they feel like if they've already kind of geared up and spent the money to get ready for this trial setting, then you kind of have to be ready. It may be tough. I don't disagree with that, but you kind of have to, you know, we live in a profession. We all have to be prepared, unfortunately. And I understand your position, Mr. Kaplan. But anything else we need to chat about? Oh, a couple things for the trial. If we do it next week, or if y'all want to move it a week, that's okay too. Is I want to make sure, and Ms. Colliers is writing this down. Mr. Kaplan, you might want to write this down as well. I'm going to want a proposed judgment from both sides before the trial. I'm going to want a proposed findings of fact, conclusions of law from both sides before the trial, and all of the exhibits. And Tony, if you could kind of explain how you want to get it. All the exhibits need to be emailed to my court reporter and my court coordinator before the day of the trial so that I can get them as well. And Tony, do you want to kind of give any thoughts about that, or anything do you think is helpful? You've seen some of these now.
Yeah, I would like to, if they can preserve the hard copies for me, and you can either mail them to the courthouse or to my home at a later time. But what I've been experiencing is they're so voluminous. Like, I don't know how many exhibits y'all have, but like I've had some for one exhibit was like 200 pages, and it's just, I'm not equipped for that. So just go ahead and email them, but also preserve the hard copies as well.
Yes, ma'am.
And one other thing, couple other things. How long do you think this is going to take to try?
Your Honor, right now plaintiffs have 2 witnesses that they intend on calling. I imagine with our breach of contract claim being settled and findings of fact on that today, that it really just moves to our fraud inducement claim. So, Your Honor, I would say plaintiffs could put on their case in chief maybe in 4 hours to give the court leeway.
Mr. Kaplan?
Your Honor, I have 1 witness plus the cross. You know, I'm hoping this is all done within a day. I was hoping the whole case could be done within 4 or 5 hours. I was, with respect to the legal fee issue, I didn't know whether or not that's something we'd do by affidavit after the fact. But, you know, probably looking at, I was thinking 4 to 5 hours for the entire trial. But I have 1.
I usually do in non-jury cases. I just do them during trial. It's easier to do it that way. If it's I understand with a jury, it can get things complicated. So I usually, if the parties want to, I'll try those separately. But with the non-jury, I'd rather just do them all at once.
Right, so that'd be, so they'd have 3 witnesses, then not 2.
Correct. Yeah. And Your Honor, in accordance with what you just said, we'll submit the affidavits and all the proper exhibits for the attorney's fees and damages before the court as well.
You don't need a real affidavit. Are you going to have a witness testify to it, or are you going to do the affidavit, just an affidavit?
I may prep an affidavit just in case if that would be quicker and more convenient for the court. Of course, Mr. Stafford will be ready to be called up and I can question him live as well.
Mr. Kaplan, what do you prefer?
Your Honor, if they're going to do an affidavit, I prefer an affidavit to save time, but I prefer the opportunity to do a controverting affidavit. I'm not sure when I'll have that opportunity, but assuming we put on the evidence in chief.
No, we're just going to do this live. It's easier to do for both of you and for me, so we'll just do this live. Now, one kind of X factor in this is I do have quite a few other trials set for next week. A lot of them are quickly going away, so I think there's a very good chance we'll reach you on Tuesday, but I don't know where you are on the docket. I don't know if you've looked at that, but there is a possibility. I'm going to try these kind of back to back, so we may or may not start on Tuesday, but just, be aware of that. You're not necessarily going to be number one, but we're going to try them back to back until we get them all done.
So Your Honor, so I'm clear. So when will we know, number one, but number two is, I'm assuming then that the docket's for the week then, so that we can be called anytime during the week?
Yeah, I'm sorry, Mr. Kaplan. So the way this works in Dallas County is that we're going to provide you Zoom instructions. If my coordinator hasn't sent them yet, she will. She'll send you Zoom instructions. You'll sign up at just like you did today at 9 o'clock. I'll go through the docket in order based on the age of the case. Oldest cases go first. So let's say the first case says we need an hour, then you're the number 2 case, then I would have you come back at 10, but you have to be there at 9 o'clock for docket call so that I can figure out who's going to trial when.
Excellent. Thank you, Your Honor.
And your clients need to be ready, because I think there's a pretty good chance that you'll go first, but it's not for sure. So I just wanted you to kind of know that.
A few housekeeping matters, Your Honor, if you have
Sure.
the time. I want to confirm, we're confirmed for Tuesday, the 12th. And then would Your Honor like a proposed finding of facts for the breach of contract issues submitted later today for this hearing?
No, just cool it all together.
Okay. And then final question, Your Honor, is plaintiffs are happy to submit a brief to the court if you'd like over the specific issue of this fraudulent inducement counterclaim. I know you just read the reply, so I just wanted to offer that. We're happy to
I'll say it again, which is, you want to go to trial on Tuesday, I'm going to decide it on Tuesday.
Perfect.
You want to move it, then I'll look at the summary judgment in detail.
That's perfect.
I don't see how this case would be completely resolved in summary judgment anyway, so you might as well just try it.
Oh, happy to. Yes, Your Honor.
Did you have any other questions? And also, when you're submitting the exhibits, make sure that you submit a couple other things I want you to go over. I want you to confer on each of your exhibit lists. Do that by Monday. The trial starts on Tuesday. And I want to be able to pre-admit as many exhibits as possible. And you each need to submit to me an exhibit list, and preferably with what's been admitted, what hasn't. But if not, I can do that. That'll be the first thing that we do once your case starts, is I'm going to go ahead and try to pre-admit as many exhibits as we can.
And also, can they make sure that they're already pre-marked?
Oh yeah, we're having a lot of problems with that. You got to make sure those are pre-marked when you scan them and send them to us. And if you're technologically savvy enough, it'd be great if it has a hyperlink to each one. But if you can't, that's okay. Mr. Kaplan, I didn't mean to interrupt you. You were about to say something.
No, when you said hyperlink, I'm like, I'm not technologically savvy. I apologize.
It's all right. We're all adjusting. Anything else we need to chat about?
Not from plaintiffs, Your Honor.
Nothing.
No, Your Honor.
All right, guys, we'll see you next Tuesday. If you settle between now and Tuesday, please let us know. Otherwise, we'll see you Tuesday at 9 o'clock.
Thank you, Your Honor.
Thank you.
Guys, be safe, and we'll see you
Your
next
Honor.
week. All right, bye-bye.